Welcome to Talk Trials.
It is good to be back in the saddle.
Today, we are looking at a maneuver in the federal courts that is, for lack of a better analogy, the legal equivalent of pulling the emergency brake on a speeding train. It is desperate, it is incredibly loud, and usually it gets you in a lot of trouble with the conductor. We are talking about the Writ of Prohibition.
Specifically, we are looking at the recent Federal Circuit opinion in Re Darnell Carter, case number 2026-110.
And just to set the stakes here, this isn't just a story about a guy who didn't want to pay his taxes. I mean, it starts there.
It often does.
But this deep dive is really about power. It's about who controls the courtroom, the judge or the litigant. And what happens when a litigant tries to tell a federal judge, stop, you are not allowed to ask me that.
It is a fascinating study in what we call jurisdictional hygiene.
Jurisdictional hygiene. I have that circled in my notes. It sounds clinical.
It is clinical. And in the federal system, it is absolutely ruthless. If you don't wash your hands, legally speaking, you don't get to perform the surgery. You're not even allowed in the operating room.
So let's establish our mission for this deep dive. We have the Federal Circuit's order, the underlying docket from the Court of Federal Claims, and we need to unpack the incredibly high bar for these extraordinary writs.
Yeah.
We want to understand why the appellate court, the Federal Circuit in this instance, usually refuses to intervene in ongoing trial court proceedings, and why Darnell Carter hit a brick wall.
To understand that wall, you have to understand the momentum of a lawsuit. Once a case starts, it is designed to roll toward a final judgment like a boulder.
Right.
Carter tried to stop the boulder halfway down the hill, and, well, you can imagine how that turned out.
Before we get into the physics of that boulder, let's get the snapshot. Give us the headline.
The headline is a denial, a swift and a pretty unequivocal denial. The United States Court of Appeals for the Federal Circuit, with a panel consisting of Judges Rana, Bryson, and Stark, denied Darnell Carter's petition for a writ of prohibition.
And the target of this writ, who was he trying to prohibit?
He was targeting the lower court judge, specifically Judge Richard A. Hurtling of the United States Court of Federal Claims.
So he's not just disagreeing with the judge, he's asking the judge's bosses to step in and muzzle him, essentially.
That's a great way to put it. Carter essentially asked the appeals court to issue an order forbidding Judge Hurtling from enforcing a specific command he had given.
That is a bold move. It's not, Judge, I think you're wrong. It's, appeals court, please silence this judge.
Exactly. And the Federal Circuit's response was a resounding no. The core rationale, if we boil it down to the absolute essence before we get into the weeds, is that extraordinary writs are not substitutes for the normal appeals process. You cannot use a nuclear option just because you are annoyed by a procedural hurdle.
Yeah.
You have to play the game according to the established rules.
Okay, that's the holding. But to really understand why this failed and why the court reacted the way it did, we need to understand the environment where this started. The U.S. Court of Federal Claims.
Right.
This isn't your standard district court where you sue your neighbor for crashing into your fence.
No, not at all. The Court of Federal Claims, or the CFC, is a unique beast in the American legal system. It is often called the People's Court, but that is a bit of a misnomer.
How so?
Because it's not for disputes between people. It is the specific venue where you go to sue the United States government for money damages.
Sovereign immunity is the elephant in the room here.
Always. It's the starting point for everything that happens at the CFC. The basic principle, going back to English common law, is that you cannot sue the king, or in our case, the government, unless the king gives you permission.
Right. The government has to consent to be sued.
You can't just drag the government into court because you're mad. The CFC exists because of the Tucker Act, where the U.S. government essentially said, okay, we waive our immunity for certain things, contract disputes, takings claims, and tax refunds.
But that waiver comes with strings attached.
Massive strings. Thick steel cables, really. And this is where Darnell Carter got tangled up. He is suing for a tax refund. He claims the IRS owes him money.
Pretty common type of case at the CFC, I'd imagine.
Very common. But here's the thing. You might think, okay, file the lawsuit, let's go to discovery, let's argue about the tax code.
But it doesn't work that way with the IRS.
Not even close. Before you can walk through the doors of the federal courthouse, you have to exhaust your administrative remedies.
That's the key phrase, isn't it?
It is. That is the legal term. It means you must have filed a formal claim for refund with the IRS directly. You have to give the agency a chance to fix the mistake first. You have to play in their sandbox before you can come play in the courts.
This is the ticket to the dance. No ticket, no entry.
Precisely. And this isn't just a procedural rule like staple your papers in the top left corner. This is jurisdictional.
Explain that distinction. That's a big one.
A procedural rule is, a rule of the game. If you break it, maybe you get a penalty, maybe the judge tells you to fix it. But jurisdiction is about the court's fundamental power. If the court lacks jurisdiction, it's not a real court for your case. It's just a room with a person in a robe. They have no authority to do anything.
So if you haven't filed that claim with the IRS first,
the court literally does not have the power to hear you. Anything they do is null and void.
And this brings us to the trigger event. Judge Hurtling is managing this case. He looks at the file and effectively says, I need to verify that you have a ticket. He issues a show cause order.
Let's pause on show cause. To a layperson, that sounds intense. Show cause why you shouldn't be held in contempt, or show cause why you shouldn't be thrown in jail.
Yeah, it has a very dramatic ring to it.
But here in civil procedure, it's more technical. It's actually a pretty standard tool.
Right, it's a burden-shifting mechanism.
Exactly. The judge is saying, I have a concern. The law requires X for me to have jurisdiction. Currently, the record doesn't show me X, so show me cause why I shouldn't dismiss your case for lacking X. In this case, show me you filed the claim with the IRS, show me the receipt.
It sounds eminently reasonable. It sounds like basic due diligence.
Yeah.
If I'm a judge, I don't want to waste a year on a trial only to find out halfway through that I never had the power to hear it in the first place.
Hey, that is the efficiency argument. It's also a separation of powers argument. The judge must ensure he is staying within the power Congress gave him.
Of course.
But look at it from a litigant's perspective, specifically a pro se litigant, someone representing themselves, or even just someone deeply suspicious of the government.
Okay.
The judge is asking for documents that you might feel you've already provided, or maybe you think the government should already have them. The thought process could be, why do I have to prove I filed it? The IRS knows I filed it. There's a trap.
But in a tax case, the burden of proof is on the taxpayer, isn't it? The government doesn't have to prove they don't owe you. You have to prove they do.
Correct. The presumption is that the IRS's assessment is correct. You, the taxpayer, have to come forward with the evidence to overcome that. So Judge Hurtling orders Carter. Submit the documentation you filed with the IRS. He wanted proof of the claim.
And this is the fork in the road. Option A, Carter uploads a PDF of his IRS claim form. Case proceeds. Maybe he wins, maybe he loses, but the case moves forward.
Right. The simple, direct path.
Option B, Carter declares war on the procedure itself.
He chose option B. He didn't file the documents. He didn't argue that he couldn't find them or that he needed more time. Instead, he filed a petition for a writ of prohibition with the federal circuit.
Let's define this weapon. A writ of prohibition. It sounds medieval. I prohibit thee.
It dates back to English common law, so that's not far off. It is the sibling of the writ of mandamus.
Mandamus orders someone to do something.
Mandamus says, do this. Prohibition says, do not do this. It is an order from a superior court to an inferior court to stop them from exceeding their jurisdiction or acting in a way that is a clear abuse of power.
So Carter is arguing that Judge Hurtling does not have the power to ask him for those documents.
That is the implication. He is arguing that the show cause order is so out of bounds, so illegal, so fundamentally wrong that the appellate court needs to intervene right now to stop it. He wants to freeze the trial judge's actions.
This brings us to the legal analysis. Because the Federal Circuit does not take kindly to being asked to micromanage trial judges. They have a standard for this, and the opinion mentions a specific Supreme Court case, Cheney.
Yes, Cheney v. U.S. District Court for D.C. This is the 2004 decision involving Vice President Dick Cheney and the Energy Task Force. It's a landmark case for this area of law.
And it sets the modern standard for these types of writs.
It is the gold standard. Whenever you see a petition for a writ of mandamus or prohibition, you're going to see a citation to Cheney.
And how does the court in Cheney, and subsequently here, characterize this writ?
They call it a drastic and extraordinary remedy. They emphasize that it is reserved for really extraordinary causes. They use all this heightened language to signal that this is not a tool for everyday disagreements.
So this isn't just a standard appeal where you argue the judge made a mistake.
Yeah.
You have to prove that something has gone fundamentally, drastically wrong.
You have to prove that the judge isn't just wrong, but that they're acting like they're not even a judge anymore, that they've gone rogue.
Wow, okay.
To determine if things have gone that wrong, the court uses a three-part test. If you fail any one of these prongs, you lose. It's a gauntlet.
I want to walk through this test because this is really the meat of the decision. What are the three things a petitioner like Carter must prove?
Under Cheney, to get this writ, you must show three things. First, that you have no other adequate means to get what you want.
No other way to solve your problem.
Right. Second, that your right to the relief is clear and indisputable. It can't be a close call. It has to be obvious.
So not just that you're probably right, but that you are undeniably right.
Exactly. And third, even if you show those first two things, the court must be convinced that the writ is appropriate under the circumstances. It's a discretionary backstop.
Okay, let's take them one by one and see how Carter did. Spoiler alert, he didn't do well.
No, he did not. It was a complete wipeout.
Let's look at prong one. No other adequate means. This is usually where these petitions die, isn't it?
It is the great filter, and it is where Carter's petition died immediately. No other adequate means essentially asks, are you trapped? If the judge makes a mistake, is the only way to fix it? Is the harm irreversible?
The court says no. Why? What was the other adequate means available to Mr. Carter?
The normal appellate process. It's the simplest answer. The remedy is that he can simply raise his challenges on appeal after the lower court makes a final judgment.
I love the analogy of the movie theater here. You don't get to interrupt the movie to complain about a scene. You have to wait until the credits roll to write your review.
That is the essence of the final judgment rule, which is a cornerstone of federal appellate practice.
So what would that look like in practice for Carter?
Well, he has a few options in the trial court. He could file the documents under protest, or he could refuse to file them and explain why he thinks the order is wrong. The judge would then likely dismiss his case for lack of jurisdiction.
And
then he has a final appealable order. He can go to the federal circuit and say, Judge Hurtling was wrong to dismiss my case, and here's why. That is an adequate mean. He isn't trapped. He just has to wait.
It reminds me of a parent telling a child, tell me the whole story before you start crying. The appellate court wants the whole story, the final judgment, before they get involved.
Yes.
They don't want to hear about every scraped knee along the way.
If they didn't have that rule, the appellate courts would be paralyzed. Imagine if every time a judge denied a discovery request or set a trial date you didn't like or admitted a piece of evidence you hated, you could immediately pause the trial and appeal.
Trials would take 50 years.
It would be absolute chaos. It would weaponize the appellate process to bleed opponents dry through delay and expense. So the adequate means prong is the gatekeeper.
Is there any situation where this prong is met before a final judgment?
Yes, but they're rare. The classic example is a discovery order that would force you to reveal privileged information, like conversations with your attorney.
Right, because once that bell is rung, you can't unring it.
Exactly. The harm is immediate and irreversible. Appealing after the trial is over doesn't help because your secrets are already out. That's a situation where there is no other adequate means. But asking for a jurisdictional document? That doesn't create any irreversible harm.
So Carter fails the first prong decisively. Yeah. But the court also looked at the second prong, the clear and indisputable right. This is the merits argument.
This is where the argument really falls apart. To get a writ, you have to show that the judge is doing something so obviously wrong that it's undeniable. You have to show you have a right to stop him that is not just plausible, but clear and indisputable.
And was Judge Hurtling doing something undeniably wrong?
Quite the opposite. The Federal Circuit ruled Carter did not show a clear and indisputable right to relief. The implication here is that a trial court has the inherent right, and in fact, the duty to ask for proof of jurisdiction.
This goes back to that jurisdictional hygiene concept we mentioned at the top.
Federal courts are courts of limited jurisdiction. They do not have the general police power of a state court. They can only hear cases that the Constitution and Congress have specifically allowed them to hear.
They have to stay in their lane.
They have a constitutional and statutory duty to ensure they are staying in their lane. So if a judge suspects he lacks jurisdiction, he is obligated to check. It's not optional.
So when Judge Hurtling asked for the IRS documentation, he wasn't picking on Carter.
No, he was checking the engine light. He was doing his job. Carter's argument seems to imply that the court should just take his word for it, or that the request itself is some form of harassment. But in a tax refund suit, that piece of paper, the IRS claim, is a jurisdictional fact. Without it, the case is a hallucination. It has no legal reality.
So not only did Carter not have a clear and indisputable right to relief, it seems like the judge had a clear and indisputable duty to ask the question.
That's the perfect way to frame it. The judge's right to ask was far more clear and indisputable than Carter's right to refuse.
So Carter fails prong one because he can appeal later. He fails prong two because the judge was doing his job. Prong three appropriateness doesn't even matter at that point.
It's game over. Once you fail one of the first two, the court doesn't even need to get to the third. The petition is denied, and any pending motions were also denied as moot. The Federal Circuit essentially said, go back to the trial court and handle this there.
I want to push back on this for a second, playing devil's advocate. We talk about efficiency in the final judgment rule. But for a litigant like Carter, who might be representing himself, isn't this process incredibly opaque? He gets a show cause order. He panics. He thinks the judge is rigging the game. He files a writ because he thinks that's how he protects his rights. Is the system too rigid for the average person?
That is a fair critique of the complexity of civil procedure. I mean, the vocabulary alone, writ of prohibition, show cause, exhaustion of administrative remedies is a barrier. There's no question about that.
It's like a different language.
It is. However, the counter-argument is that the rules of jurisdiction aren't just red tape. They are structural. They are constitutional. They define the separation of powers.
Right, because the Court of Federal Claims literally cannot take money from the U.S. Treasury and give it to Carter unless Congress has authorized it via the Tucker Act, and he has met all the conditions.
Correct. A judge acting without jurisdiction is a judge acting as a tyrant. They are exercising power they don't have. So Judge Hurtling's inquiry, checking his own jurisdiction, is actually a protection of the rule of law. He is making sure he has the authority before he uses it. It protects the government, it protects the taxpayer, and ultimately it protects the integrity of the judiciary.
So it's a feature, not a bug, even if it's a confusing feature.
I think that's right. The system gives pro se litigants some leeway on procedural rules, but jurisdiction is the one thing no one gets a pass on. Not the litigant and not the judge.
Let's pivot to the strategy here. We see these writs pop up occasionally. Are they ever successful? Or is this always a losing battle?
They are rarely successful. We see them succeed in cases of severe privilege disputes, as we talked about, or in situations where a court is blatantly ignoring a mandate from a higher court.
Give me an example of that.
Let's say the Federal Circuit heard an appeal, made a decision, and sent the case back down to the trial court with specific instructions, like dismiss this case with prejudice.
Okay.
And imagine the trial judge just said, no, I disagree with the Federal Circuit. I'm going to hold a trial anyway. In that scenario, you would absolutely get a writ of prohibition. That is a court going rogue, a clear usurpation of power.
But for a discovery dispute or a jurisdictional check?
Almost never. It's the wrong tool. It's like trying to use a sledgehammer to fix a watch. You're going to do more harm than good, and you're not going to fix the watch.
So why did Carter do it? We have to ask.
That is the million-dollar question. And since this is a deep dive, we can read between the lines and speculate a bit.
What are the possibilities?
There are two main possibilities, and they're not mutually exclusive. One, ignorance. He simply misunderstood the procedural mechanism and thought this was the standard way to object to an order he disagreed with.
Plausible. Civil procedure is hard, especially for a non-lawyer.
Very plausible. Two, obstruction.
Meaning?
He doesn't have the documents. Think about it. If you don't have the proof that you filed the IRS claim, you know your case is dead on arrival. The moment you answer the show cause order with, I don't have it, or you provide something that isn't the right form, the case is dismissed.
So you kick the can down the road.
You file a writ of prohibition to stall. You try to freeze the proceedings, create confusion, maybe hoping the government lawyer gets frustrated and settles, maybe just buying time. It's a delay tactic. A Hail Mary pass not to win the game, but to keep the clock running for a few more seconds.
But in the federal appellate system, that clock runs out fast, doesn't it?
Very fast. The Federal Circuit turned this around quickly. They didn't let it sit there and fester. They saw it for what it was, a meritless attempt to circumvent the trial court, and they shut it down.
Now, I want to step into our deliberation room. It is time for the 10th chair.
The 10th chair.
Sitting as the 10th chair. And just a reminder to our listeners, this is the podcast's independent analysis for discussion purposes only. We are just two voices in your headphones. This is not legal advice.
We are putting on our robes, metaphorically.
We are imagining ourselves on the panel. We've heard the arguments. We've read the Carter petition. We see Judge Hurtling's order. How do we rule?
I am affirming the denial of the petition without hesitation. I mean, this is probably one of the easier decisions we'd make all year.
I am right there with you. It seems like the only logical conclusion. Walk us through the reasoning for our 10th chair opinion. Why is this so open and shut?
First and foremost, procedural efficiency. The entire federal court system is built on the principle of the final judgment rule. Allowing a writ of prohibition here would set a dangerous precedent. It would essentially greenlight interlocutory appeals for routine case management orders.
And what would that lead to?
It would allow litigants to stall cases indefinitely by appealing routine show cause orders. We simply cannot have a system where a simple, necessary question from a judge triggers a full-blown federal appeal. The system would collapse under its own weight.
That makes sense. What about the role of the trial judge?
That is the second point, judicial authority. Trial judges must have the autonomy to manage their dockets and verify their own jurisdiction without constant micromanagement from the appellate court.
They need to be able to run their own courtroom.
Exactly. Judge Hurtling is the captain of his ship. He needs to be able to ask the passengers for their tickets without the admiral flying in on a helicopter every 5 minutes to second-guess him. We have to trust trial judges to handle these basic, foundational issues.
I like that analogy. And finally, the adequate means logic.
This is the safety valve, and it's a critical part of our reasoning. The petitioner isn't being harmed irreparably. He is not being denied his day in court, not permanently. If the case is dismissed for lack of jurisdiction because he fails to provide the documents, he can appeal that dismissal.
That's his adequate remedy.
That is the adequate mean. There is no emergency here. No rights are being extinguished forever without review. He just has to follow the proper sequence.
But let me ask you this, sitting in the 10th chair. Is there any part of you that worries about the show cause power being abused? Could a judge use show cause orders to harass a litigant they don't like? Show cause why your font size is 11.5 instead of 12. Show cause why you filed on a Tuesday.
Theoretically, yes, a judge could be a petty tyrant, of course. But that brings us back to adequate means. If a judge dismisses your case because of font size, the Federal Circuit will reverse that in a heartbeat on regular appeal. The abuse would be so obvious.
So the normal appeals process is sufficient to correct that kind of abuse?
Absolutely. You don't need a writ of prohibition to fix a petty error. You need a writ of prohibition to stop a usurpation of power.
That's a key distinction. Abuse of discretion versus usurpation of power.
Exactly. Being a jerk or making a bad call is an abuse of discretion, and it gets fixed on appeal. Acting like a king, ignoring the law, and exercising power you don't possess, that is an usurpation. Judge Hurtling asking for IRS papers is neither. It is basic responsible judging.
So what is the projected impact of this ruling? What message does our 10th chair opinion send?
I think this ruling serves as a warning to future litigants. Do not use extraordinary writs as a delay tactic or a way to avoid answering simple, direct questions from the trial judge. It reinforces the high wall around the Cheney factors.
It's a signal to the bar.
It tells practitioners and pro se litigants, unless you have a truly novel, dangerous situation, like an imminent violation of a core constitutional right or a clear privilege, keep your writs to yourself, follow the rules.
It really emphasizes that the appellate court is not a shortcut.
It is not. It is a review board, not a panic button. And it's definitely not a tool to be used for strategic gamesmanship.
And specifically regarding tax cases, what's the takeaway there?
It signals that the jurisdictional prerequisites in tax cases, the administrative filing with the IRS, are non-negotiable. They are the price of admission. You cannot waive them, you cannot hide them, and you cannot prohibit a judge from asking about them.
So Darnell Carter goes back to the Court of Federal Claims. The writ is denied. What happens next on the ground?
Well, Judge Hurtling's show cause order is still active. The clock, which was paused while the writ was pending, is now ticking again. Carter has to produce the documents or provide a very, very good reason why he cannot.
And if he doesn't?
Dismissal. It's almost certain. Likely dismissal for lack of subject matter jurisdiction, which is a dismissal without prejudice on the merits, but practically speaking, might be the end of the line for him.
Why is that?
Because if the statute of limitations for filing that claim with the IRS has run, he might not be able to go back and fix the problem. So the jurisdictional defect becomes a permanent bar.
So the writ of prohibition was really just a detour on the road to a likely dismissal.
A costly, time-consuming detour that probably didn't win him any friends at the trial court or the appellate court.
Before we wrap up, I want to leave the listener with a final provocative thought. We talked about how the writ is a drastic remedy. In the modern legal system, we prioritize efficiency over almost everything else. We want cases to move. We want finality.
Efficiency and accuracy, those are the twin goals, sometimes in tension with each other.
Right. But is there a danger that in our worship of efficiency, we make the system too hostile to the outlier, to the person who actually does have a unique, catastrophic procedural problem, but gets swept away because the courts are so used to saying no to these writs? Are we conditioning judges to just deny them out of hand?
That is the risk. That is the fundamental tension. When you set the bar at clear and indisputable, you are essentially saying, we will only fix the obvious mistakes, the ones that jump off the page. Subtle injustice or a novel legal issue that isn't yet indisputable might slip through the cracks of a writ of prohibition.
And the litigant is just told to wait.
They're told to wait, even if waiting causes some harm. But that is the price we pay for a system that handles hundreds of thousands of cases. We rely on the final appeal to catch the subtle stuff. The writ is for the house fire, not for the leaky faucet.
So the system says, be patient. Justice is coming, but it's taking the bus, not an ambulance.
That is a perfect way to put it. Unless you were bleeding out on the floor, wait for the bus.
Well, Darnell Carter didn't want to wait for the bus. He tried to call a helicopter, and the Federal Circuit hung up the phone.
And now he's walking.
That's a wrap on Henry Carter. A short case, but a deep lesson in how the gears of the federal courts actually grind.
And a reminder to always check your jurisdiction before you file. And if a judge asks you for it, you should probably just give it to them.
As always, remember, our analysis here in the 10th chair and throughout the deep dive is for informational and discussion purposes only. It is not legal advice and does not represent the actual holding or views of the Federal Circuit.
Always consult your own counsel.
We would love to hear your thoughts on this deep dive. Have you ever tried to file a writ of prohibition? Have you ever had a judge issue a show cause order that felt unfair? Let us know.
Until next time.
Thanks for listening to Talk Trials.